Oakland, California, Monday morning, May the 18th, 2026. A federal jury retires to consider a verdict form with 8 questions. Behind them, 3 weeks of testimony, 11 days of evidence, 20 witnesses, 6 tech billionaires on the stand. In front of them was Musk's question. Did OpenAI's leaders breach the charity he says his early donations helped create? Less than 2 hours later, they come back. They have answered the first 2 questions out of 8. The other 6 did not get answered. Jill Horwitz of Northwestern Law. The public interest in the nonprofit loses, no matter who wins or loses this trial. The lawyers for OpenAI exchange hugs in the well of the court. None of the 3 billionaires is present to see it. Within an hour, Sam Altman is tweeting about the latest version of ChatGPT, with no mention of the trial. The case was Musk v. Altman, in federal court in Oakland, before Judge Yvonne Gonzalez-Rogers. Musk filed it in 2024, 2 years before the trial. He brought 3 claims: breach of charitable trust against Altman, Brockman, and OpenAI, unjust enrichment against the 2 of them, and a Microsoft aiding and abetting claim tied to the first. The donation grounding the trust was Musk's roughly $38 million to OpenAI's nonprofit in its early years. The remedy he asked for was on a different order of magnitude: $134 billion in ill-gotten gains, removal of Altman and Brockman, the unwinding of OpenAI's 2025 recapitalization, which converted its for-profit subsidiary into a public benefit corporation. The money, if returned, was to go to the OpenAI charity, not to Musk. Judge Gonzalez-Rogers, an Obama appointee who once presided over Epic v. Apple, bifurcated the trial: liability before an advisory jury, remedies before her alone. The jury could advise. The judge kept the binding pen used, one law professor told CNBC, when judges want community judgment or cover in a highly visible case. This case was both. The jury was 9 people, 6 women, 3 men. Their names have not been publicly released. The judge was, by all accounts, warm with them. She brought them chocolates on one occasion. With the lawyers, she was less indulgent. "You do not want to be held in contempt, I guarantee you," she told one of them on a Tuesday. During the first week, when both sides veered into a debate about whether OpenAI or XAI was the more dangerous AI safety risk, she cut them off. The trial, she reminded them, was not about whether artificial intelligence had damaged humanity. And a beat later, dryly, she said plenty of people would not want humanity's future in Mr. Musk's hands. The verdict form, reported by MLEX before deliberations, had 8 questions on it. The first 2 were limitations questions. Did Musk's claims accrue after August 2021 for the OpenAI defendants and after November 2021 for Microsoft, 3 years and 2 years before he filed? If the answer to either was no, the case was time-barred and the jury would not reach the merits. Questions 3 through 8 were the merits questions the jury never reached. Before the case became a calendar problem, it became a character trial. Musk's lawyers built their case partly on what former OpenAI insiders had said, on the record, under oath, about Sam Altman. They played video depositions of 3 of them to the jury. Helen, a former OpenAI board member who voted to fire Altman in November 2023, testified that she was used to the board not being informed about things. She described a pattern of behavior related to his honesty and candor, her phrase, and named that pattern as the reason for the firing vote. Natasha McCauley, another former board member who also voted to fire Altman in 2023, said the board had real doubts that we could trust what the CEO was telling us. She also described buckets of concerns about him. Mira Murati, OpenAI's former chief technology officer, who briefly served as interim CEO during the November 2023 weekend before Altman was reinstated, testified that Altman had a pattern of saying one thing to one person and completely the opposite to another person, and was creating chaos at the company. 3 former insiders, 3 depositions, 3 different formulations of the same credibility problem. A text exchange between Altman and Murati during the ouster was entered into evidence. Altman, can you indicate directionally good or bad? Murati, directionally very bad. Altman took the stand himself on May 12th. His lawyer's first question on cross-examination was direct. Are you completely trustworthy? I think so, Altman answered. Later, I believe I am an honest and trustworthy businessperson. Altman did not accept the word lying. He called the 2023 firing a miscommunication and a breakdown in trust. He said he had returned to OpenAI after the firing because he was willing to run back into the burning building to try to save it. But the credibility war was not one-sided. Musk took the stand for 3 days at the start of the trial, in a crisp black suit, and answered cross-examination from OpenAI's lead lawyer, William Savitt. I was a fool who provided them free funding to create a startup. He told the jury funding he put at $38 million, paid into what became, in the trial's market context numbers, an $800 billion company. Savitt produced documents the OpenAI side argued cut the other way. A 2017 email from Musk to a Tesla vice president after he hired Andrej Karpathy away from OpenAI to work at Tesla. The OpenAI guys are gonna want to kill me, but it had to be done. An admission under questioning that xAI, Musk's own AI company, founded in 2023, partly distills OpenAI's models. The courtroom audibly gasped. And meanwhile, every one of these character beats was also evidence on a different question, the question of when Musk knew. Altman, on his own time on the stand, returned the character fire. He recounted a 2017 conversation in which Musk and the other co-founders had asked Musk, if he had control of OpenAI, what would happen to that control if he died? Altman's account, Musk replied that control of OpenAI should pass to my children. Then, during closing arguments, Musk's lawyer Stephen Molo turned that into a bridge over a gorge, marked with a sign, built on Sam Altman's version of the truth. Walk across, Molo asked the jury. On the same day, OpenAI's lawyer Sarah Eddy made the structural counter in her closing. He never cared about the nonprofit structure, she said of Musk. What he cared about was winning. And meanwhile, Musk, whom the judge had ordered to remain available during closings, had flown to China with President Trump. Underneath the character demolition was the structural question. The question was, can the legal form, a nonprofit foundation, contain the capital form, a for-profit subsidiary the trial put at $852 billion? Musk's witnesses said no. David Skitzer, his nonprofit governance expert, testified that OpenAI's governance was inconsistent with the customs of nonprofit law. Musk's lawyer Molo, in his closing, sharpened the point. The OpenAI nonprofit, Molo said, nominally controls the for-profit. But in practice, 7 of the nonprofit's 8 board members also sit on the for-profit board. The nonprofit, Molo told the jury, had hired employees only 1 month before the trial started. It does grant-making, not AI research. Molo then played the jury a video clip of Altman himself, saying that the 2023 board's failure to fire him was its own kind of governance failure. OpenAI's defense answered. Daniel Hemel testified that 92% of the 100 largest U.S. charities have for-profit subsidiaries, normal practice. John Coates rebutted Skitzer as unsupported. In her closing, Sarah Eddy gave the defense one sentence. The OpenAI nonprofit is the best-resourced nonprofit in the world. The 2 pictures sat on the trial record together, the nonprofit with no staff. The nonprofit that is, by Eddy's claim, the wealthiest charity in the world. Microsoft's chief executive Satya Nadella took the stand and described the partnership. A $13 billion core investment, custom supercomputers, cloud capacity, an exclusive commercial license, Azure revenue, profit share, and equity return rights. And after OpenAI's 2025 restructuring, rights post-AGI and an eliminated cap on Microsoft's return. Wired, reporting on the same testimony, put Microsoft's total partnership spend at more than $100 billion, and noted, from the trial record disclosures, that Microsoft now holds a larger share of the OpenAI for-profit than the nonprofit foundation does. None of that in the verdict was reached. The next exhibit was not governance theory, it was electricity. Sam Altman testified that he had tried to steer OpenAI's purchasing toward Helion Energy, a nuclear fusion company. He also testified that he owns about a third of Helion. 6 days earlier, on Friday, May the 8th, the U.S. House Oversight Committee opened an investigation into Altman's potential conflicts of interest. In the same window, the attorneys general of more than 6 U.S. states asked the Securities and Exchange Commission to review those potential conflicts before any OpenAI initial public offering. And also on the trial record was a piece of testimony. This channel anchored a previous episode on Sam Altman on May 12th, saying he did not believe he could get $200 billion into a nonprofit. The capital form, in his own admission, constrains the legal form. All of this was on the trial record. By the time the lawyers finished their closing arguments on Thursday, May the 14th, every piece of it was in front of the advisory jury. The only question that mattered was whether the jury would reach any of it. Monday morning, the 18th of May. The advisory jury retired to deliberate. The damages phase opened in parallel before Judge Gonzalez-Rogers alone. 2 hours did not pass. The jury came back, unanimous for all defendants on all claims. They had answered the first 2 questions on the 8-question form. Musk had reason to know of the alleged breach before August 2021 for the OpenAI defendants, before November 2021 for Microsoft. The case was time-barred. The other 6 questions did not get answered. Judge Gonzalez-Rogers accepted the advisory verdict from the bench. The damages phase, which had begun running that morning, was halted on the liability finding. The lawyers for OpenAI and Microsoft exchanged hugs and backslaps. None of the 3 billionaires was present. None of the 9 jurors stopped to speak with reporters. Inside an hour, 2 readings of what had just happened were on the public record. They contradict each other. Both are partly correct. Elon Musk, on the social network he owns, called it a calendar technicality, and alleged in the same post that Altman and Brockman had enriched themselves by stealing a charity. The court did not adjudicate that allegation. He said he would file an appeal with the Ninth Circuit, framing the case as a precedent question, whether donors can be left without recourse against charities, in his words, that have been looted. William Savitt, OpenAI's lead lawyer, told reporters outside court that he disagreed with the framing. "It's not a technical decision, it's a substantive one," he said, adding that Musk had brought the claims too late and had brought them as a weapon, not as a charity rescue. Microsoft, in a written statement, said it welcomed the jury's decision to dismiss the claims as untimely. Sam Altman, less than an hour after the verdict, was tweeting about a new ChatGPT release. He did not mention the trial. The judge, on the way to wrapping up, addressed Musk's lawyer's reservation of appeal. "There's a substantial amount of evidence to support the jury's finding," she said, "which is why I was prepared to dismiss on the spot. Musk's appeal will be on the limitations question." The trial judge had already rejected one version of that argument before the jury ever got the case. Whichever doctrine the Ninth Circuit hears, the obstacle is steep. Appeals on statute of limitations findings the trial judge has already reviewed are, in the legal expert's language, one paper collected, very hard to win. And the alternative path, California's Attorney General has independent standing for charitable trust matters, has, on this fact pattern in this window, not moved. What the verdict explicitly does not say. It does not say whether the conversion was a breach. It does not say whether Altman and Brockman were unjustly enriched. It does not say whether Microsoft's $100 billion position is the fruit of a breach, or whether the 2025 restructuring Public Benefit Corporation post-AGI rights for Microsoft, no return cap, is lawful. It does not say whether California charitable trust law has the doctrinal capacity to constrain a for-profit subsidiary, now valued at $852 billion. A charitable trust is a triangle, 3 vertices, the settlor who donates and creates the trust, the trustee who holds and administers it, the beneficiary to whom the trustee owes the duty. In OpenAI's founding document, the beneficiary is, in the founding language, humanity. In the trial, Musk played the settlor and lost on timing. He filed too late. Altman, Brockman, and OpenAI played the trustee and won on procedure. They did not have to defend the merits. 2 of the 3 vertices fought in court. The third was not represented to a merits determination in this case. California charitable trust law gives the Attorney General independent standing to bring such an action for that vertex. On this fact pattern in this window, the Attorney General did not. Jill Horwitz returns, a nonprofit that doesn't have any voice, in her words, and doesn't have the money or staff to exercise its duties. What remains now runs on 2 clocks. 1 clock began before the verdict. The House Oversight Committee investigation opened on the Friday before closing arguments. The state attorneys general's letter to the SEC asking for review of Altman's potential conflicts before any OpenAI public offering. Those continue. They are not the trial, they are accountability mechanisms running on a different clock. The other clock begins after the verdict. The Ninth Circuit appeal, stated by Musk's lawyers but not yet docketed. The California Attorney General's continued silence. The third vertex of the triangle remains where it was. Our earlier episodes argued that OpenAI's legal form had lost fiduciary discipline and that its capital form had outgrown the nonprofit shell. This episode is what happens when those arguments go to a federal jury and the question never gets answered. The cold open question was whether OpenAI's leaders breached the charity Musk says his early donations helped create. The verdict is that the court did not answer it. The case carried 3 claims, an advisory jury, and a $134 billion remedy that could matter only if the limitations gate opened. On the stand, the fight became one about timing, whether Musk understood the structure he had funded before he sued. In the expert testimony, the disagreement was structural, whether a charitable trust theory could reach OpenAI's modern legal form at all. The answer the legal system did give came in less than 2 hours. 2 limitations questions answered, time barred, 6 merits questions left untouched. That procedural answer is not the civic answer. The settlor and the trustees fought while the beneficiary named in the founding promise, humanity, had no voice in the merits room. What remains runs on 2 clocks. Musk's Ninth Circuit appeal is stated, not filed. California's Attorney General is silent, not foreclosed, and the House Oversight Inquiry and State Attorney General pressure on the SEC were already ticking before the verdict. So the last image is the first image after the case. Altman posting about ChatGPT, not the trial, the lawyers gone, the beneficiary vertex still outlined, still without a voice, still undefended. If this changed how you see your next receipt, your next bill, your next upgrade, we did our job. Like and subscribe, we have more to show you.